Hello, everyone, and welcome to the webcast. My name is Christine Dursey Davis. I'm the Executive Director of the Ohio chapter of APA and Chair of the New Urbanism Division, and I'm your webcast moderator. Today is Friday, June 22nd. It's officially summer. We will be hearing the presentation Native American Tribes, Law and Planning. For technical help during today's webcast, type your questions in the chat box found in the webcast toolbar to the right of your screen, or you can call the 1-800 number shown there in bold. For your content questions related to the presentation, again, type those in that questions box located to the right of your screen in the webinar toolbar. We'll answer those at the end of the presentation during the Q&A. On your screen is a list of our sponsoring chapters and divisions for 2018. Thanks to all the participating sponsors for making these webcasts possible and free to their members. If you're looking down the list and you don't see your chapter or division listed, we ask that you reach out to them and suggest that they join. Today's webcast in particular is sponsored by the New Mexico chapter of APA, and you can learn more about them and what they're up to at apa-nm.org. On your screen is a list of our upcoming webcasts. You can register for these by visiting our webcast webpage, ohioplanning.org/planningwebcast. To log your CM credits for attending today's webcast, just head over to planning.org, log into your My APA account, and up there at the top, you can search for CM activities, either by entering the title of today's webcast or the event number, both of which can be found on our webcast webpage, ohioplanning.org/planningwebcast. And this webcast has been approved for 1.5 CM credits for live viewing only. We do have some recorded webcasts that are available for distance education, and you can check that out by visiting, again, our webcast webpage. Like us on Facebook, Planning Webcast Series, to receive up-to-date information on our sessions. And we are recording the webcast today. If you head over to YouTube and search Planning Webcast, you can view a recording of it, or you can download a PDF of the presentation by visiting our webcast webpage. Okay, with that, I'm going to go ahead and just quickly introduce today's speaker and then turn it over to her. Sharon Hausum has been the planning program manager for the Pueblo of Laguna for the past 9 years and has worked with tribes for over 20 years. She's also adjunct faculty at the University of New Mexico and an instructor for Northern Arizona University's Institute for Tribal Environmental Professionals. Dr. Hausum has a doctorate in urban and regional planning from the University of Wisconsin-Madison, where her dissertation focused on Native American and non-Native interactions in planning processes. She has a master's in environmental studies from Yale University, and she is AICP. So with that, I am going to turn it over to Sharon.
Great, thank you, Christine, and thanks for having me present this webinar. As Christine noted, I've been working as a planner in Native American communities for over 20 years, starting with an internship with the Spokane tribe in Washington State, and then working with Pueblos and other tribes in New Mexico, either directly or through regional planning. My mission in this work is to support people's relationship with their environments, and that creates the foundation for my work in planning and my work with tribes. I'd like to start this off with a few questions for you, which we'll do through an interactive poll, which you can respond to by clicking on the screen. Christine, can you start the first poll?
Okay, I went ahead and launched it. And the question is, do you work for a Native American tribe or Indigenous people? And we'll just ask that you go ahead and click yes or no there right on your screen. And we'll give it a few moments. Well, I like this. Everyone is voting very quickly. We've got like almost 80% voted already. This is great.
The yes, no probably helps support that.
It does help. It's just very quick, isn't it? Okay. I'm going to go ahead and close it, and then I'm going to share the results. So 97%, hey, no, I don't work for a Native American tribe or Indigenous people, which leaves us 3% saying yes.
All right. Can you see my screen again?
Yes, we are back to your screen.
Terrific. So the American Planning Association surveys members regarding their employers and salaries, but they don't have a category for tribal governments. So we don't know whether all of you are a representative sample or not. We can see that in 2016, 70% of APA members responding to the survey worked for public agencies. That could include tribal governments, along with local, state, and federal government agencies, regional planning organizations, school districts, and others. So now let's see how many of you have a sense of how many tribal governments there are in the United States. Can we have the next poll, please, Christine?
Okay, it is launched. As of January 2016, according to the Federal Register, how many federally recognized tribes were there in the United States? 142, 366, 566, or 708? And we have answers all over the board so far. So I'll give it a few moments here. Okay. I'm going to go ahead and close it and show our results. So 14% say 142, 38% say 366, 34% say 566, and 14% say 708. So our largest group is with 38% at 366 federally recognized tribes. How do we do?
Very interesting.
We're back to your slide.
Right. The correct answer is 566. So
okay.
Given that the distribution of answers was pretty broad, I'm not quite sure what to make of that. I will say that the number, the 566 includes over 200 native entities within Alaska. So those of you who chose 366, if you weren't counting Alaska, you would have been closest there. And I'm going to talk more about how a tribal government is defined in this talk. I have one more question before we move on with that. Christine?
Okay. And I'm launching it now. As of the 2010 US Census, what percentage of the United States population was American Indian or Alaska Native? So our choices are 0.9%, 1.2%, 1.7%, and 2.4%. So go ahead and vote. Give it another moment. Okay, I'm going to go ahead and close it. These margins are pretty close though, so it's hard. Okay, so I'm going to go ahead and share the results with everyone. 14% say the answer is 0.9%. 33% of our respondents say 1.2. 33% say 1.7, and 20% say 2.4. So we have a tie here. 33% of the group here think that 1.2% of the population is American Indian or Alaska Native, and another 33% say 1.7. So tell us, what's the answer?
The answer is, again, C, 1.7%. And I think maybe some people just like the B and C answers because those are usually the correct ones anyway. I will say that 1.7%, just to be clear, is the American Indian or Alaska Native population alone or in combination with other races. Those of you who answered A, 0.9%, that's the percentage of the population that's American Indian or Alaska Native alone, just one race. So that population is for the United States as a whole, and there are many states and cities that have much higher percentages of American Indian and Alaska Native people. In Alaska, for example, 19.5% of the population was American Indian or Alaska Native, alone or in combination, according to the 2010 census. The next highest states in order were Oklahoma, New Mexico, South Dakota, Montana, North Dakota, and Arizona. Cities in those states also tend to have high percentages of American Indian and Alaska Native populations. And there are also other cities with high percentages, such as Green Bay, Wisconsin, which is where the Oneida Nation is located, and Tacoma, Washington, where part of the Puyallup tribe's lands are located. There are also high numbers of American Indian and Alaska Native residents in other large cities, though they may not have high percentages. New York City had over 111,000 AIAN residents in 2010, and Los Angeles had over 54,000. The presence of tribal governments and American Indian and Alaska Native peoples is one reason why they're important for planning. The population data that I just touched on is a reminder that Native or Indigenous peoples are neighbors living adjacent to non-natives on tribal lands or in cities and other areas with non-natives. There are also other reasons related to social justice why planning with Indigenous peoples is important. This is one of our responsibilities as planners. One of the aspirational principles of the AICP Code of Ethics states that we shall seek social justice by working to expand choice and opportunities for all persons, recognizing a special responsibility to plan for the needs of the disadvantaged. Keep in mind that the entire United States was once tribal land. The United States process of colonizing these lands, as with its colonization of other lands and the process of colonization in general, has resulted in Indigenous peoples being subjected to cultural, social, political, economic, and environmental injustice. This map shows original pre-contact homelands of tribal nations across what's now Canada and the lower 48 of the United States, using the tribes' names for themselves, which are often not still in use. And this map shows the progression of tribal land loss across the United States, with the red showing past and current lands as of 1990. We can see some of the impacts of this in economic indicators, which show much lower per capita income for American Indian and Alaska Native persons than for those who are white alone. In fact, lower per capita income than for any other race based on 2016 one-year American Community Survey data. The per capita income for AIAN persons is just over half that for those who are white. And the data also shows the highest rate of unemployment for AIAN individuals. In order to work effectively with tribes or for tribes, it's important to understand their unique legal status and how it affects planning. That's because tribes themselves view this status as foundational. U.S. Supreme Court Justice William Brennan's question, after all, if a policeman must know the Constitution, then why not a planner, may be even more relevant for planning with Native American tribes. So given that, and because this session, I've been told, is eligible for certificate maintenance law credit, this talk is primarily about legal frameworks. There's a lot of great work happening in planning related to Indigenous design and planning, which takes a more philosophical and also a more creative approach. And a good place to get information on that is the Indigenous Design and Planning Institute at the University of New Mexico. You can see the outline for the rest of this presentation on the slide. I'm going to start off by talking about sovereignty. Planning is essentially an act of governance, of decision making, and sovereignty defines who makes those decisions and, in this case, the constraints under which they're made. I'll then talk about land jurisdiction because that defines the boundaries where those decisions are made, the geographic constraints. And then I'll talk about demographics. We all need to understand the populations in the communities that we serve, the number of people, their socioeconomic characteristics, and the housing where they live. But because of their legal status, there are unique considerations related to tribal demographics. And then I'll talk about how tribes' legal status affects specific planning areas: land use and zoning, housing, environmental protection, historic preservation, and economic development. Sovereignty is the authority of an independent political entity. It refers to the ability of a government to govern itself and its people. Tribes are understood to be sovereign governments. Although there are limitations on this, sovereignty is a fundamental value and a foundation of work with tribes. It's important to note that sovereignty is inherent, meaning that tribes had it, the ability to govern themselves, before Europeans came to this country, and did not lose it unless they explicitly agreed to give up some part of it. You can see a statement by George W. Bush on sovereignty on the screen. And aside from it being a little awkwardly worded, it's incorrect because it says that tribes were given sovereignty. They were not given sovereignty, they already had it. Treaties are an indication that tribes were recognized as being sovereign entities, since they're only made with foreign sovereign nations. At the time that the United States was taking shape on the East Coast, Europeans were recognizing the legitimacy of indigenous peoples, Native Americans or American Indians, and signing treaties with them. Treaties were signed to establish peace in a new country and to build alliances, rather than explicitly with the purpose of recognizing the nationhood of Indian peoples. But the treaties did mean that tribes were dealt with as sovereign entities on an equal footing, and agreements were reached together. Not always in good faith, but they were negotiated. An era of treaty making started in 1778 with the Delaware tribe, and it ended in 1871 when the United States Congress stated that no more tribes were to be recognized as independent nations with which to make treaties. The importance of treaties is also noted in the Constitution, where they're described as the supreme law of the land. The Constitution also acknowledges tribes in two other ways. The first is in Article 1, Section 2, Representation and Taxation, where Indians are mentioned as not taxed. The implication is that tribes are outside the reach of American government and its taxing power. The second mention is in Article 1, Section 8, defining the powers of Congress. Congress has the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. And this is known as the plenary power of Congress, the definition of plenary being complete in every respect, absolute, and unqualified. When the states adopted the Constitution, they surrendered their authority over tribes to the federal government. The other side of this, though, is that Congress can make decisions regarding tribes rather than tribes having complete power over everything that might affect them. An early example of Congress exercising this power is a series of acts known as the Intercourse Acts. You can mentally substitute the word interaction to be clear about their purpose. They were intended to protect trade and interactions between Native Americans and non-natives and preserve peace on the frontier. Remember that the United States had multiple interests with Native American tribes. They wanted to be able to trade with them for goods such as beaver pelts, and they also wanted to make sure that whites could settle the lands. The acts were designed to a limited extent to protect tribes. The Act of 1834 was the final Trade and Intercourse Act, and it was similar to previous acts. It referred to protection of Indian rights to their land by setting boundaries and restricting whites from entering and making unauthorized settlement of tribal lands by non-Indians a federal offense, denying individuals or local governments the right to acquire land from Indians by purchase or other means, regulating Indian trade, controlling sales of liquor and then eventually prohibiting it, punishment of crimes committed by members of one race against the other and compensation for damages, and promotion of civilization and education among Indians to absorb them into American society. So you can see by this that the acts were partly protective of Indian lands, but also very controlling and geared towards assimilating tribes into US culture, particularly through promoting civilization and education. The next few slides are taken from some tribal websites, and I've circled the areas that you can see are emphasizing the importance of their sovereignty and treaties. And this is from the Tulalip tribes, and the first sentence is, "Sovereignty is a most valued asset to the people of the Tulalip tribes of Washington state." Though the concept of sovereignty is complex and undoubtedly open to interpretation, the principles of tribal sovereignty are very fundamentally solid. This slide from another tribe down at the bottom notes that the Sugar Island residents came to understand that while the treaties granted large tracts of land to the federal government, the documents did not end their sovereignty or terminate their ancestral right to hunt and fish on the ceded lands and waters of the Anishinaabeg. And this slide is from the Confederated Tribes of the Umatilla Indian Reservation, and I've circled the mention of the sovereign authority to protect the rights reserved by the Treaty of 1855. So the word reserved there is significant. It relates to those inherent rights of sovereignty that were retained even with the treaty. However, in addition to Congress's plenary power, U.S. Supreme Court cases have had the effect of limiting tribal sovereignty in practice by reducing tribes' authority over land and their self-governance. There were 3 Supreme Court cases in 1823, 1831, and 1832 that are very significant. They were all decided under Chief Justice John Marshall, so they're known as the Marshall Trilogy. The first case is Johnson versus McIntosh, which was decided in 1823, and which has to do with tribal ownership of land. The plaintiff, Johnson, bought land from the Piankashaw tribe in 1773 and 1775 in what's now Illinois. His descendants inherited it. The defendant, McIntosh, obtained the land from the federal government as a land patent. The question in the case was who had the right to dispose of, to sell the land, the tribe or the federal government. McIntosh, who obtained the land from the federal government, argued that tribes did not own the land but lived in a state of nature without private property rights. Therefore, they could not have sold the land to Johnson. Since they didn't own the land, the doctrine of discovery applied, they argued. This refers to the principle that if a European power goes to a country that another European power hadn't previously explored, it can claim the land as its own. Chief Justice John Marshall referred to the doctrine of discovery in this case. He said that the British had obtained the land via the doctrine of discovery, and the United States government had obtained the land from the British and now had title to it, and was in effect a landlord for Native Americans. The United States ownership was subject to ongoing rights of Native American tribes to occupy and use the land, but the tribe could not sell the land on its own. The second and third cases in the trilogy involve the Cherokee Nation and relate to how tribes are defined as nations and how they govern themselves. Both occurred when Andrew Jackson was president of the United States, and Jackson was a proponent of removing tribes from their land and moving them west forcibly. He encouraged passage of the Indian Removal Act, which Congress passed in 1830. And the map on the slide shows some of these removals. While that was happening at the federal level, the state of Georgia was trying in its own right to get control over Cherokee land and the Cherokee people. They passed a law that effectively abolished Cherokee laws, and they created the Georgia Guard to enforce Georgia's laws on Cherokee territory. In the case of Cherokee Nation versus Georgia, a Cherokee named Corntassel was convicted in Georgia State Court of murdering another Cherokee. John Ross, who was the principal chief of the Cherokee, had the support of people in Congress, but not the support of President Jackson. So he went to the U.S. Supreme Court and asked for an injunction against Georgia laws that they be stopped. Justice Marshall allowed the appeal to the Supreme Court and stayed the execution, stating that Georgia should wait to execute Corntassel for the capital crime. The Cherokee argued that the Cherokee Nation was a foreign nation in the sense of our Constitution and law and was not subject to Georgia's jurisdiction. They filed this under Article 3, Section 2 of the Constitution, which allows foreign countries to bring a case to the Supreme Court. While the case was pending, the state of Georgia executed Corntassel anyway. Then the Supreme Court dismissed the case, concluding that an Indian nation was not a state or a foreign nation within the meaning of the Constitution, so the Cherokees could not take a case against Georgia to the U.S. Supreme Court on those grounds. Chief Justice Marshall described tribes as domestic dependent nations and noted the relationship of tribes to the federal government as that of a ward to a guardian. In the third case in the Marshall trilogy, Worcester versus Georgia, Samuel Worcester, a missionary, and 6 other missionaries were living and preaching on Cherokee land. Georgia had a statute that said they had to register with the state in order to be on Cherokee land, which they had adopted because they were concerned that the missionaries were not siding with the state, but with the Cherokee, and they wanted to keep track of them. Worcester and another man were targeted by Georgia because they supported the Cherokee. They hadn't registered with the state, so they were in violation of the statute. Under that statute, they were arrested and jailed just a week after the Cherokee Nation versus Georgia case was dismissed from the Supreme Court. But in this case, the Supreme Court upheld the right of the missionaries to live and work within the Cherokee lands under Cherokee laws and Cherokee treaties with the United States. So the result of this case was the precedent that tribes do have a right to self-government and Indian territory is not governed by the states. The takeaways from the Marshall Trilogy are therefore the federal government owns tribal land, but tribes have the right of occupancy. In terms of their sovereignty, tribes are not the equivalent of foreign nations, but are domestic dependent nations functioning as wards under guardians. And tribes have the right of self-governance and state laws do not apply on tribal lands. So we see in some ways tribes retain parts of their sovereignty, the right to occupy their lands and to adopt and enforce their own laws, not state laws. But in other ways, their sovereignty was reduced by not owning the land and not being considered true foreign nations. As I mentioned earlier, there were 566 federally recognized tribes as of 2016. Each tribe has its own history, which means that each has its own story related to its current authority and jurisdiction. Some tribes have treaties, some do not. Some interacted with the Dutch and British, while others interacted with the French or Spanish, and then later with the United States. And each of the colonial powers had different ways of engaging with tribes. I'd like to talk about some examples, especially from New Mexico, and also mention Alaska and Hawaii because their situations are quite different. But in the interest of time, I'm going to hold off on that until the end of the presentation and come back to them if we have time. In addition to the ways that tribal sovereignty has been recognized and how it was affected by Supreme Court cases, I want to talk more about the ways it's been adapted and compromised since the 1930s. In 1934, the U.S. Congress adopted the Indian Reorganization Act, also known as the IRA or the Wheeler-Howard Act. The IRA dealt with the actual framework for tribal governments. It authorized tribes to adopt constitutions and bylaws, negotiate with federal, state, and local governments, and to continue to exercise their existing powers. But the Constitution still had to be approved by the federal government through the Secretary of Interior, so they do demonstrate limitations to sovereignty. The tribes that adopted constitutions typically have governments that look like US governments, not necessarily like their traditional form of government, which might be considered an erosion of their sovereignty. Technically, they can still define their own government structure, but most followed a model that the IRA provided. Starting in the 1950s, the federal government began to enact more laws that negatively affected sovereignty. In 1953, Congress enacted Public Law 83-280, known as PL 280, which gave civil and criminal jurisdiction on Indian lands to 5 states: California, Minnesota, Nebraska, Oregon, Wisconsin, and then Alaska. And there's a couple exceptions of tribes within those states. The intent was mostly to address criminal jurisdiction, since non-tribal neighbors thought there had been some breakdown in law and order. Civil jurisdiction was something of an afterthought, but PL 280 did open up state courts to litigation that had previously only been in tribal or federal courts, and it led to some questions about authority for land use and zoning decisions. Eventually, through the Indian Civil Rights Act in 1968, states were allowed to return jurisdiction to the federal government, and they couldn't take on jurisdiction for new tribes without the consent of the tribe. Also in 1953, the US Congress adopted House Concurrent Resolution 108, which called for Congress to terminate tribal status, that is, to eliminate tribal governments. One of the ideas behind termination was to cut federal budgets by cutting services to tribes. The resolution itself didn't terminate tribes, but it set the stage for future individual acts of Congress that did terminate tribes. Some tribes that were terminated include the Menominee, Klamath, Siletz, Grand Ronde, various Paiute tribes in southern Utah, and also rancherias in California. Termination meant that tribal sovereignty was effectively ended. There was no longer a trust relationship with the federal government, programs were discontinued, state legislative and judicial authority were imposed, and tribes could be taxed. In 1958, the Secretary of the Interior announced there wouldn't be any more termination, and in 1970, President Nixon asked for a new concurrent resolution to repeal termination. In 1973, the Menominee Restoration Act was passed, restoring the tribal status of the Menominee, and other tribes also continued to work towards having their tribal status restored. Tribes also started to push to regain their sovereignty in other ways, building on the momentum of their protests against termination and broader civil rights activism that was happening at the time. In 1975, this helped lead to the Indian Self-Determination and Education Assistance Act, Public Law 93-638. It's often referred to by the number, which allows them to contract with the federal government to manage services. So where there's a federal program to provide services to tribes, and the federal government has historically managed that program itself, this act gives the tribe the authority to use the federal funds and manage the program itself. And the process is known as 638 contracting. Later amendments to the Self-Determination Act adopted in the 1980s and 90s expanded on this with what's called self-governance. Under compacting, tribes manage the program as it was structured within the federal government. Under self-governance, tribes have more flexibility in design of programs and may receive consolidated funds as block grants to implement those programs. The Self-Determination Act does not restore full tribal sovereignty, but it's helped strengthen tribal government roles and organizational capacity. We've been talking about the constraints on tribal sovereignty, but we also need to recognize the other side of that, which is the protection of the federal government. You'll remember the ward and guardian concept that emerged in Cherokee Nation versus Georgia. Under that principle, the federal government has the responsibility to ensure that tribes are protected from states and state law, as well as private encroachment on their lands. This is linked to what's known as the trust responsibility related to a confidence or a trust, and has been described as being of the highest fiduciary responsibility. The responsibility is especially important when it comes to land management, because technically the federal government does own the land, as you'll remember from the Johnson versus McIntosh case. The land is held in trust status in contrast to fee simple, which is how most private property is held. Tribes can own land in fee simple too, but that is another discussion. The Bureau of Indian Affairs, which is in the Department of Interior, is the main federal agency working with tribes, but the trust responsibility applies to all branches and agencies of the federal government. Department of Housing and Urban Development, Health and Human Services, Federal Highway Administration, Department of Agriculture, and the Environmental Protection Agency all have trust responsibilities. This also creates what's known as a government-to-government relationship, which means that the tribe is supposed to have access to the highest levels of federal government agencies, not just lower-level staff. And it serves as a foundation for consultation with tribes on federal department and agency decisions. In the year 2000, President Clinton issued Executive Order 13715, which required federal departments and agencies to consult with Indian tribal governments when considering policies that would impact tribal communities. Consultation does not necessarily mean that tribes' perspectives have to affect the final decision, just that there must be an opportunity for them to be heard. Sometimes this works well for tribes and sometimes not as well. What may be more important is tribes' authority to regulate their own affairs. On their own and with their own people, they're generally not subject to local government or state government authority. They can adopt a form of government and operate it, including adopting laws and ordinances. They can define who's a tribal member, regulate property, regulate business, levy taxes, regulate non-members in their activities on the reservation, with some caveats, as well as other powers. One of the authorities that's somewhat unique to tribes is determining tribal membership, though of course the United States does do this with citizenship. As planners, it's very important to distinguish between being a tribal member and living on tribal lands. If you call a tribal enrollment office and ask about the tribal population, they're going to tell you who's an enrolled member. Enrolled members may or may not live on tribal lands, and enrollment offices may or may not keep records of where enrolled members are living. Tribes have always had traditional ways of recognizing the members of their communities, but in the late 1880s and early 1900s, the federal government began to make an issue out of who was officially an American Indian and who was not. They were going through the process of taking land away from tribes, and they wanted to determine how much land was needed for people who were considered to officially be Indian. They did this through the General Allotment Act, also known as the Dawes Act, which was enacted in 1887. The Allotment Act states that the recognition of tribal members may be administered using the laws and customs of the tribe, but being a descendant of a tribal member does not necessarily qualify someone to be a member as well. That set the stage for what's now the most common criterion for tribal membership, the percentage of Indian blood that a person has, often known as the blood quantum. That actually came up a little later in the Burke Act of 1906, which referred to whether a tribal member was, quote unquote, competent and capable of managing the lands that were allocated to that member. The idea, the racist idea, was that if a person wasn't 100% Indian, he or she was more likely to be competent and capable. This led to tracking how Indian, what percentage or blood quantum a person was. Now many tribes themselves require 1/4 blood quantum, 25%, to be enrolled. But in addition to the language in the Allotment Act, the US Supreme Court has also found that tribes have the authority to define enrollment criteria for themselves. The case that dealt with this was in New Mexico, Santa Clara Pueblo versus Martinez in 1978. A woman from Santa Clara Pueblo, Julia Martinez, had married a Navajo man, Miles Martinez, and had children with him. At Santa Clara, in order to be enrolled, your father has to be enrolled. So the children whose father was Navajo were not enrolled. And that meant that they couldn't inherit their mother's home or the right to live on Santa Clara land or vote in Santa Clara elections. Mrs. Martinez brought a lawsuit to federal court. The district court said that the membership rules were part of social definition and were basic to the tribe's survival as a cultural and economic entity. The 10th Circuit Court found that since the difference was based on gender, the enrollment rules were unlawful. When the US Supreme Court heard the case, they disagreed with the 10th Circuit and let Santa Clara Pueblo's enrollment stand. And they commented on how the membership requirements were related to, quote, tribal autonomy and self-government. So this is all very important for planners because, as I mentioned, it's important to determine whether you're counting the enrolled population or the resident population when you're thinking about services. In addition to that, it can make it challenging to do population projections, which we all need as planners, because of the possible loss of tribal membership due to blood quantum. If a tribe does require 1/4 blood quantum, 25% Indian blood, then a child with one parent who's 1/4, but another parent who's less than 1/4 wouldn't be able to be enrolled. It's not usually possible to get information on the blood quantum of every member, so you can't easily project forward how many tribal members there will be in the future. As the graphic shows, this also is a concern for some tribes as blood quantum may be decreasing as going into the future. As I've said, tribes also have the authority to regulate activity within their lands. So that means it's important to know exactly where those lands are. The map that I showed you earlier indicated that every part of the country is at least one tribe's homeland, if not multiple tribes. But over the course of history, as we well know, tribes lost most of that land. In areas colonized by the British, tribes lost land through wars and treaties and being pushed west. In areas colonized by the Spanish, Spain held that the land was all owned by the king and then distributed land grants that were much smaller than tribes' ancestral areas. Under the United States, settlement pushed further west, and the Homestead Act gave parcels of land to settlers, land that had belonged to tribes. When the lands were surveyed to confirm their ownership, some of the surveys were fraudulent or done incorrectly, causing tribes to lose more land. And then when the railroad went through tribal lands, it was given land not just for the tracks, but to sell to raise money for the infrastructure. If you think about federal lands, such as national forests and national parks, keep in mind that those were also tribal lands as well. Alaska Native communities effectively lost their lands under the Alaska Native Claims Settlement Act, and Hawaii was essentially annexed into the United States without real consideration of the Native Hawaiians living there. And when tribes were terminated, their land lost its trust status. It was no longer protected by the federal government and could be sold. I touched on the Allotment Act, also known as the Dawes Act, and its relationship to the Homestead Act. This is one of the most insidious ways that tribes lost land and one of the most far-reaching in terms of its impacts on tribal land use and planning. To allot something means to assign a share or a portion, and the intent of the General Allotment Act was to split tribal land into parcels, provide each household or family with a parcel, and then give the rest of the land to white settlers. The tribal lands would no longer be held in trust as communal property, but would be private property, fee simple. In addition to the General Allotment Act, there were additional acts that allotted specific reservations, especially in Oklahoma, where tribes ultimately lost all their land through the kinds of land rushes depicted in the poster on this slide. Originally, the idea was that the allotted lands would still be held in trust by the federal government for 25 years. But the Burke Act of 1906 allowed the Secretary of Interior to transfer the land to private property, fee simple, sooner than that. And once that happened, the tribal members could sell their land and it was also taxed. Many lost their land this way, including through not being able to pay the taxes on the land. So while in 1887, after tribes had already lost land through treaties and other processes, they still held 138 million acres. By 1934, they only had 52 million acres, less than 40%. Allotment was ended by the Indian Reorganization Act, the same act that led to a lot of tribal constitutions and government structures. But when it ended, the allotted lands that were still in trust status did not go back to being held communally by the tribe. They're now held in trust by the federal government for the descendants of the original person or family that received the allotment. The land can't be sold, so instead the rights to it are split into smaller and smaller fractions as it's inherited. And this is where things start to become really interesting for land use planning. Within the boundaries of one reservation, there are typically multiple land ownership types. There's the land that was originally held in trust for the tribe that still has that status. Then there are the allotments that are held in trust. And then there's the land that was lost. And this pattern, as you can tell by looking at this map, is called the checkerboard. You can tell why. This slide has an example from the Crow tribe. The checkerboard also means it's difficult to know who might be living within the boundaries of the tribe's land. Because much of the Crow tribe's land was lost, there are now many people who are not native living there, over 20% according to the US Census. Most tribes did continue to lose land, but many have also had land added to their reservations. The Navajo Nation, for example, had land added through executive orders. And they also received land through another type of allotment known as a public domain allotment. Native people were allowed to settle on lands that others hadn't taken, similar to any other homesteader. So although this was largely a good thing, it resulted in the same kind of checkerboard pattern that came from the other type of allotment. These checkerboard patterns with both tribal and non-tribal land within the original boundaries of the reservation create issues for jurisdiction. On the one hand, the land's within the original boundaries and the tribe should have jurisdiction over that land as a matter of sovereignty and for consistency. On the other hand, there are non-tribal members living there, they have private property, and they don't get to vote for the tribal officials who are making the tribal laws, which means they wouldn't get a say in the laws that affect them. So this sets up a difficult situation, which was bound to end up in the courts. One of the most significant cases was Montana versus United States in 1978. This case was on the Crow Reservation, and it had to do with the Crow tribe's regulation of duck hunting and fishing by non-tribal members on their own private property, fee land, within the boundaries of the reservation. Most planners aren't probably working with duck hunting and fishing regulations, but it sets a very important precedent. In the Montana case, the U.S. Supreme Court considered the current status of the lands, noting that even though a treaty with the Crow tribe had allowed for tribal jurisdiction of the lands had subsequently been lost by the tribe through the Allotment Act, thus causing the tribe to lose authority over those lands. The court also considered the tribe's authority to regulate through inherent sovereignty and found that this sovereignty was now limited to what was necessary to govern itself or its internal relations. The court held, in this case, regulating the conduct of non-Indians on non-Indian lands was not clearly related to self-government or internal relations. However, the court also noted that there are situations in which tribes may exercise jurisdiction over non-tribal members on their own land within the boundaries of the reservation. There's two exceptions. If a non-member entered into a consensual relationship with the tribe, such as a contract or a lease, and when that conduct threatens or has some direct effect on the political integrity, the economic security, or the health and welfare of the tribe. In this case, the Crow tribe hadn't argued that non-Indian hunting or fishing was presenting a threat to its subsistence or another aspect of its welfare, so that wasn't considered here. The case sets an important principle that tribes' inherent sovereignty is now limited to what they need to govern themselves, not to govern others. But it also does set up reasons when tribes might govern others within their boundaries. The Montana case takes us directly to a case that may interest planners more, a case about zoning, again within the exterior boundaries of tribal lands within a checkerboard area. Brendale versus the Confederated Tribes and Bands of the Yakama Indian Nation, which took place in Washington State. The case considered the authority of Yakama County versus the authority of the Yakama Nation to zone two distinct parcels of land, both owned by non-tribal members, within the exterior boundaries of the Yakama Reservation. Both the county and the tribe had zoning codes. One parcel owned by Wilkinson was located in an area of the reservation where roughly 80% of the residents were non-tribal members. It was called the open area. Half of the open area was private property and fee simple, and non-members were not restricted from living in this area. Wilkinson wanted to subdivide a 32-acre fee simple parcel into 20 parcels. And this conformed to the county zoning, but not to the tribal zoning, which was for agriculture and had a minimum lot size of 5 acres. The other parcel, owned by Brendale, was located in an area where a majority of the land was held by tribal members, and this was called the closed area. Brendale wanted to subdivide a 160-acre fee simple parcel with 2 parcels to be used for trailer sites and recreational cabins. And again, this conformed with Yakama County zoning, but not tribal zoning. Yakama County designated it as a forested watershed, which allowed residential development, campgrounds, lodging, restaurants, and general stores. Under the tribe, the area was restricted to harvesting of wild crops, grazing, hunting and fishing, and camping. And construction in the area was limited to the tribe and the Bureau of Indian Affairs strictly for natural resource management activities. The case was decided by the United States Supreme Court on a plurality, with no true majority for either parcel and with the decisions based on multiple factors. One of those factors was the role of the Dawes Act, the General Allotment Act, which 4 justices said meant that, following the Montana case, the tribe did not have jurisdiction over non-member activities on lands it had lost. 3 of the justices dissented on this and said that the exterior boundaries of the reservation were still intact, and because of that, the tribe had the authority to zone both parcels. So the final decision was ultimately based on the votes of the other 2 justices, who used a legal principle of equitable servitude that went with the land itself, and said that although the land was lost through the Dawes Act, the tribe still retained some authority over it based on the tribe's own power to exclude and the essential character of the land. Based on those principles, they said that the tribe did not have the authority to zone the open area for Wilkinson and did have the authority to zone the closed area for Brendale. You can see that the case was notable enough to make it into the New York Times. From a tribal sovereignty perspective, the Yakama Nation did have some of its authority acknowledged, but not all of it. From a planning perspective, the case reinforced the potential for very uncoordinated land use, although clearly this was happening anyway. Ultimately, the recognition of the problem has probably led to tribal and non-tribal governments realizing they need to work together and coordinate their planning more effectively to not end up in this situation. A good example of this coordination is the Swinomish tribe, also in Washington State and Skagit County. Those cases dealt with private property, fee simple land, within the boundaries of tribal lands, reservations. But there's also trust land, which is owned by the federal government and can't be sold. The trust status affects every form of development: residential, commercial, industrial, and institutional. Trust land is not private property, and a person can't just buy land that's zoned a certain way and expect to be able to build on it under the zoning requirements. The tribal government needs to approve the use, and there may not even be a zoning code in place. Since the land can't be sold, it's generally leased instead, and that requires the approval of the tribe, and because the land is technically owned by the federal government as well. The lease approval process is notoriously complicated. This flowchart shows all the steps involved. One of the key differences from leases off tribal lands is that because the federal government is involved, the National Environmental Policy Act comes into play and environmental clearances are required. And because of the nature and history of tribal lands, there's also a document called a Title Status Report that has to be prepared. All this makes it very difficult to simply get land to build a house, and it also makes it much harder to get a mortgage. Tribal regulatory authority also includes environmental protection. In many cases, states administer federal environmental laws. But remember that under Worcester versus Georgia, state law does not apply on tribal lands. There's been a long evolution and court cases related to this as well. What it's ultimately led to is that tribes have what's known as treatment as a state and administer the federal laws themselves under an approval process. This essentially allows tribes to follow the same regulations as states, federal regulations as states, as they set standards and enforce them. For the Safe Drinking Water Act, Section 1451 authorizes tribal treatment as a state. The Navajo Nation manages its public water system supervision program, which monitors community water supply system, and it and Fort Peck in Montana manage underground injection control programs, which are designed to protect groundwater. But most tribes have not assumed primacy over these programs, so the EPA manages them directly. Under the Clean Water Act, Section 518 authorizes tribal treatment as a state. And this is very significant because it means that tribes can set their own water quality standards, including designating uses of bodies of water on their lands and setting the standards to meet those uses. These have the potential to conflict with the water quality standards of their upstream neighbors, who would then have to treat the water coming off their lands or flowing into the tribal lands to meet the tribal standards. And this is what happened with the Pueblo of Isleta in New Mexico and its upstream neighbor, the city of Albuquerque. Isleta uses the Rio Grande for irrigation, recreational purposes, and ceremonial purposes. The ceremonial use includes incidental ingestion of the water. To ensure the safety of tribal members who consume this water, Isleta set the water quality standards very high, including a standard for arsenic that was 3 times higher than the federal minimum at that time, and also set a standard for ammonia that didn't vary for flows in the river, which affect the concentration, since ceremonies happen when there are low flows. And the Environmental Protection Agency approved Isleta's standards. The standards, however, would have cost the city of Albuquerque around $250 million, so they sued the EPA. The New Mexico Federal District Court and then the 10th Circuit Court upheld the EPA's decision and found that tribes can have more stringent standards than the state does. The Clean Air Act also allows treatment as a state under Section 301D of the Act. Tribes can administer air quality permits for sources on their lands but not off their lands. And they can also designate their lands as Class 1 rather than Class 2, which means that less of an increase in air pollution is allowed on them. And that, of course, also affects their neighbors who may have facilities that are producing pollution nearby, which is drifting onto tribal lands. The National Environmental Policy Act requires consideration of environmental impacts associated with federal actions such as permitting and funding. And the regulations for NEPA call for notice to tribes, and the Council on Environmental Quality has called for consultation to occur as early in the process as possible. The National Historic Preservation Act also requires, under Section 106, consideration of impacts, in this case on district sites, building structures, or objects that are included in or eligible for inclusion in the National Register of Historic Places when there is a federal undertaking. And the lead federal agency must consult with tribes on the undertaking. NHPA allows for consideration of what are called traditional cultural properties, which have association with cultural practices or beliefs of a community that are rooted in its history and are important in maintaining its cultural identity. TCPs, as they're often called, may include tribal sacred sites. So when a federal agency is considering effects of a federal undertaking and consulting with tribes, they need to think about the effect on tribal sacred sites as part of the National Historic Preservation Act. The 1992 amendments to the National Historic Preservation Act also allow tribes to assume any or all of the functions of a state historic preservation officer, a SHPO, with respect to tribal land. And now many tribes have tribal historic preservation officers. In some ways, this is analogous to treatment as a state for environmental laws because it means the federal government and the tribe work together directly. But in the absence of a TIPO, the SHPO is responsible for ensuring the protection of historic sites on tribal lands. I'm going to wrap up by talking a little bit about tribal economic development, and then we will have time for questions. One of the main differences with economic development that we see on tribal lands is tribes as governments running businesses. It's true that non-tribal governments can also do this, but since it's generally seen as competing with private businesses, they typically don't unless it's providing some important service, such as water or electricity. But on tribal lands, government-run businesses are actually very common. Under Section 17 of the Indian Reorganization Act from 1934, which I've mentioned earlier, tribes can incorporate as a corporate entity and can engage in business, obtain loans, acquire property, issue certificates of interest, transfer land, and other things necessary to conduct business. It's a quote from the Act. Many, but not all tribes operate gaming businesses. As we've discussed, states typically do not have jurisdiction on tribal lands, but this was another area that was addressed by the courts. In the case of California versus Cabazon Band of Mission Indians in 1987, the U.S. Supreme Court agreed with the 10th Circuit Court that the state did not have the authority to regulate gaming on tribal lands. This decision, however, was then weakened by the Indian Gaming Regulatory Act in 1988. And under that act, if a state prohibits a certain type of gaming, then the tribe does not get to have that type of gaming either. And the Act also creates conditions for negotiating compacts, agreements between tribes and states regarding gaming. And because of that, many tribes pay some of their gaming revenue to the state in which the gaming operation is located. With regard to other types of economic development, we've noted that tribal land can't be sold. So that's not part of economic development for trust land. There's no real housing market and no land speculation for any other purpose. And there's also no property tax, just like on other federal lands. Taxation on tribal lands is also unique. Tribal governments do not pay taxes on their own businesses to themselves or to the federal government, though tribal members do pay personal federal income taxes. The reference to Indians not taxed in the Constitution does not mean that individual tribal members are not paying taxes now. Sales taxes on tribal lands depend on who's administering the tax, the tribe or the state, where the sale takes place, who's making the purchase, what's being sold, and who else has regulatory involvement in the activity. And it's a very complex process. Tribes and states usually develop agreements to work through these issues. So with that, I hope that I've provided you with a solid base for understanding why working with tribes is important, how tribal sovereignty is the foundation for that work, the fundamentals of tribal land jurisdiction and demographics, and how these issues are tied to planning. I do have more slides on New Mexico, Alaska, and Hawaii, but I think I will hold off on those for now, and we can do questions instead if there are questions. So Christine, could
Sharon, there are a few questions.
Okay.
But why don't you go ahead with your next few slides while folks think up more questions?
Okay, I will do that. Thanks. So I'm going to talk a little bit about some examples of different tribal histories and how they've resulted or led to more of our current concepts of sovereignty. And I like to talk about New Mexico because I live here. New Mexico has some examples of tribes that have treaties and tribes that do not. And again, this is mostly about the history and the sovereignty. New Mexico was originally colonized by Spain and then Mexico, and then joined the United States as a territory in 1850 and a state in 1912. The United States and the Navajo Nation signed a treaty in 1868 and just celebrated the treaty's 150th anniversary a couple weeks ago. They recently located a third hard copy of the treaty. There are only 3 actual physical copies. Someone living on the East Coast who came out to New Mexico for the unveiling and the celebration of the treaty anniversary. In the map on the right, you can see that the 1868 block there, that was the land that was designated for the Navajo reservation at that time, and other land was added later through different mechanisms. The Mescalero Apache signed a treaty with the United States in 1853, but the formal survey of the boundaries was never done and Congress never officially ratified the treaty. And the Jicarilla Apache also signed a treaty, but the United States didn't ratify that one either. New Mexico also has 19 pueblos, including the Pueblo of Laguna, where I'm the planning program manager. And they have a very different history, which was heavily influenced by Spanish colonization. The Spanish recognized the Pueblo's authority and jurisdiction over some of their lands by designating what are known as land grants and giving Pueblo leaders symbolic canes of authority. Later, Mexico and the United States under President Lincoln also acknowledged this authority with additional canes. And the silver piece there is the head of one of the Pueblo canes. The Mexican government also recognized Pueblos as citizens through the Plan of Iguala, which was ratified under the Treaty of Cordoba. And then the United States recognized existing Mexican rights under the Treaty of Guadalupe Hidalgo in 1848. The United States also negotiated a treaty with some, but not all of the Pueblos, but it was never ratified either. The complicated part with the Pueblos is that the United States did not fully recognize them as Indian tribes or tribal governments for a period of time. An 1853 territorial law prohibiting the sale of liquor to Indians did not include Pueblo Indians. and their land was also treated like private land, which could be sold. We start to see legal cases about the status of the Pueblos in 1869 with United States versus Lucero. In this case, Cochiti Pueblo sold land to Juan Lucero, a non-native. The United States said this was not legal, basing this on the Intercourse Act, which made unauthorized settlement of tribal lands a federal offense. But the New Mexico Territorial Supreme Court dismissed the case, saying that the Pueblos weren't under the guardianship of the United States, and they weren't Indians. They based this on their ideas about what they thought other Indians were like versus the Pueblo people being law-abiding and sober. The Supreme Court affirmed the territorial court's decision in United States versus Joseph in 1876 and referred again to how the Pueblos were not like other Indians. This changed when New Mexico became a state. The New Mexico Enabling Act in 1910 stated that the term Indian included Pueblos. Later, the question went to the US Supreme Court in the United States versus Sandoval case in 1931. In this case, a non-Indian, Felipe Sandoval, was selling alcohol at what was then called San Juan Pueblo, now Okewinge, its traditional name. Sandoval argued that since Pueblos were not Indians following the decision in United States versus Lucero, it was legal for him to sell alcohol. The Supreme Court disagreed and said that the federal government did serve as guardians over the Pueblos as well and recognized them as Indians. And this put Pueblos in the same situation as other tribes as far as their sovereignty and also established their federal land status. Tribes in other states also have their own very different histories. And I mentioned Native entities within Alaska at the start of the talk when we were discussing how many federally recognized tribes there are. So I'll touch just briefly on their status. For most of its history, Alaska didn't have the same settlement pressures as the states in the lower 48. Of course, Alaska became a state much later. The Native people were not being pushed out, and there wasn't the same need to sign treaties to ensure peace and establish land boundaries. But by the 1970s, the United States wanted the oil that was available in Alaska, which it planned to transport via the Trans-Alaska Pipeline. And to run the pipeline through the state, the land status of Alaskan Natives had to be resolved. So to do this, the US Congress adopted the Alaska Native Claims Settlement Act in 1971. ANCSA, as it's known, also led to the creation of corporations chartered under the laws of the state Alaska. There are 225 village corporations which have surface but not subsurface rights to their land. And there are 12 regional corporations which have fee simple title to their own land and subsurface rights for oil and gas and other minerals for the village corporation land. The corporations are not fully sovereign entities, but they do have these land rights. In Alaska, the state has regulatory jurisdiction over the Native entities, which is very different than in the lower 48. Alaska Native villages can exercise some authority as municipalities, but there may be limitations on that depending on whether they're home rule municipalities or not. Native Village Councils, which is the governing body for the Alaska Native entity itself, essentially the tribal government, do not have the same kinds of authorities that tribal governments in the lower 48 have. For example, they don't have taxation authority based on a Supreme Court case decided in 1997. However, they are recognized by the federal government and services are provided to them. In Hawaii, the situation is yet again different. Hawaiian natives do not have one sovereign government that is recognized by the United States federal government, and they're not listed as federally recognized tribes in the Federal Register. The state of Hawaii has an Office of Hawaiian Affairs, which is responsible for improving the well-being of Native Hawaiians, including addressing environmental issues. And two of Hawaii's senators, Daniel Akaka and Daniel Inouye, were persistent in sponsoring the Native Hawaiian Government Reorganization Act, which would have provided a process to reorganize a Native Hawaiian governing body and establish a liaison with the US federal government. But there was controversy about that as well, because it would have had the same kinds of limitations on sovereignty that there are on tribes in the lower 48. There have also been some challenges in Native Hawaiian groups organizing amongst themselves. So that is all I have in the way of slides. And Christine, I will turn it over to you, and I hope we have a number of questions.
We do. First of all, I did get a few questions, clarification questions for logistical things. We will have these slides available at the conclusion of the session. They'll be available as a PDF download on our webcast webpage, ohioplanning.org/planning webcast. And we'll also have a recording available on YouTube. Just search planning webcast. And the third logistical thing is, yes, this has been approved for 1.5 CM credits. They are law credits. So I don't think I mentioned that in my introduction, but they are indeed law credits. So, okay, with that, let's go ahead and jump into questions. This one is rather timely. Are Native Indians migrating from Central and South America? And are they crossing the border without permission? And secondly, a second part to that, since New York City, for example, is a sanctuary city, are there Native American counts other than Americans within that 111,000 number that you mentioned in the beginning?
Thanks, Christine. Those questions have a number of really fascinating elements to them, some of which relate to the definition of American Indian, Alaska Native, and also tie into the larger definition of indigenous peoples, which could lead me into a really long discussion about that as well. The US Census has a number of discussions about that are ongoing, and the last census actually included Central and South Americans as American Indian or Alaska Native for the question on race. So the 2010 census data that listed, for example, the New York City American Indian Alaska Native population probably would have included Central and South American indigenous peoples if they identified themselves that way in the census. Now, the question of illegal migration depends on your perspective of that, but there are also much larger conversations about ancestral indigenous lands and border crossings. There are a number of indigenous peoples that, of course, historically would not have recognized a border between Mexico and the United States. And I'm thinking that the Yaqui, for example, have rights to cross a little more freely than the non-indigenous people between Mexico and the United States, because historically their boundaries overlapped what are now the boundaries of the US and Mexico. With regard to the sanctuary city, I think, Christine, was that more of a question about how people are counted, or did I miss something on the sanctuary city component?
I think it's how people are counted, and as a sanctuary city, do you somehow account for potentially undocumented Native Americans?
I don't know specifically how different sanctuary cities are accounting for indigenous peoples in their work with people who are migrating to the US. But the counting is definitely an interesting question in its own right.
Okay. Thank you. Next, it's not so much a question, but a statement. There is an upcoming Western Planner Tribal Planning Conference that's being held in Fort Hall, Idaho, August 5th through 8th, and the theme is building partnerships through understanding, cooperation, and consultation. And you can get more info at westernplanner.org.
Yes.
More
And the
information.
Pueblo of
There's that.
Laguna will be doing a couple other presentations there. We're really looking forward to that.
Great.
And Sherwin, if you're on, thanks for coordinating.
Next question. When state government agencies contact or notify tribes, such as issuing solicitation of view notices, is there a standard period of time during which all notified tribes must respond or forfeit the opportunity to comment?
You said such as when? Contact or notify tribes such as?
Issuing solicitation of view notices.
Solicitation of view?
Yes, that's what it says.
Okay. I'm not sure about the solicitation of view. If that might refer in New Mexico regarding notifying tribes of proposed subdivisions. I am not certain if that's what's being referred to, if New Mexico's statute has a set period of time, but I will say that tribes like the consultation process in general to be done in good faith. And sometimes we find, whether it's from the federal government or the state government, that very short periods of time do not appear to be done in good faith. We sometimes receive letters that say, if we don't hear back from you in a week, we will have assumed for you to have forfeited your opportunity to comment, and that is not in the spirit of good consultation. Ideally, what would happen instead would be building relationships over time. And the collaborative kinds of relationships between tribes and non-tribal entities that set things up such that planners know each other, other agency officials know each other, and although a formal letter needs to go out and there probably needs to be a formal comment period for whatever the topic is, staff can communicate with each other about things as well outside the formal process to make sure that conversation is open and helpful.
Okay, thank you. Next question, how much authority do tribes have regarding, this is interesting, the diversion of natural water that traverses their land for their use?
That is a very interesting question.
Yeah.
It depends on which state you live in and whether your state is governed by riparian rights or prior appropriation, which is a whole different water rights discussion. In Western states are governed, as far as water rights, generally under the law of prior appropriation, which means that whoever was there first and put the water to use has the best right to continue using that water, in a nutshell. So since tribes were generally there first, they generally have the highest priority right to use the water. There's a Supreme Court case known as Winters that discusses this and decides this. What happens in order to settle all that, though, is what's known as a general stream adjudication. And that defines not just the tribal water right, but the water rights of everyone within the area that is being discussed. And what also tends to happen as a result of that are negotiations and settlements. So depending on the outcome of that adjudication, that negotiation, that settlement, a tribe may have a variety of rights to divert water for various purposes. Negotiations and settlements also usually bring in other elements such as infrastructure. One of the things that has happened with tribes and water is that even though technically there is this priority right, if the tribe can't get the water, if the infrastructure is not there, then it's not really helping. So in negotiations, tribes will often be willing to give a little bit in terms of the priority in order to get some resources for infrastructure to actually get water. So they refer to that as paper water, the legal right to use the water, versus wet water, the actual water flowing through the tap or the irrigation system or the municipal system.
Thank you. Next question. Can you touch on the importance of federal agencies needing to consult with tribes if they could be affected somehow during a planning process? And not only federal agencies, but regional or local agencies as well. What is the process? What is the due diligence for that?
Sure. Under the Clinton administration, there was an executive order, 13715, which required all federal agencies to consult with tribes on decisions that might affect them. And under that, each federal agency developed its own regulations or memorandum about how it would go about that process, how on what kinds of decisions it would consult tribes and how it would go about consulting them. So each federal agency should have that. The actual implementation of that, would vary probably according to the overall federal administration's support for tribes, but those are in place and vary from agency to agency. There are not necessarily such requirements at the state or local level. The state of New Mexico, under Governor Bill Richardson, also had an act, actually the State Tribal Collaboration Act, which did call for state agencies to consult with tribes. I don't know how many states have laws like that in place. New Mexico also, as I was mentioning earlier, has requirements to notify tribes when subdivisions are proposed. And if there's a traditional cultural property, in addition to the National Register in New Mexico, there's also a state register. And if there is an action that might affect something on the state register, a historic property that is important to a tribe, the tribes need to be notified about that as well. As far as I know, local laws that call for notifying tribes are very rare. It would probably be unlikely that a city or a county would legislate itself to notify tribes.
Okay, thank you. Can tribes legally allow people to live on their lands who the U.S. might consider illegal immigrants?
Tribes are subject to all federal laws, so most likely not.
Okay, thank you. I have this question too. So how did you become involved initially in tribal planning? And I guess what advice do you have for others who may be interested in learning more about this career path? And I have to say, I didn't read your bio until I actually read it out loud, and I saw that your undergraduate degree is in environmental studies, and here, so is mine. And it's interesting, from environmental studies to planning. I did the same thing, not specifically tribal planning, which is sort of a real niche. So if you could just talk a little bit about that for curiosity's sake.
Yeah, niche is a very good word for it. Yeah, my master's, I actually have an undergraduate degree in biology and in art, and I have a master's degree in environmental studies and a concentration for that in social ecology and community development. So I got done with my master's and I actually didn't even know anything about planning. Didn't know anything, but I was not very familiar with the field of planning. But I did have, and I mentioned this up front, my real interest is in people's relationships with their environments. And when I was getting my master's, there was a lot of emphasis actually in the Yale School of Forestry and Environmental Studies on urban areas, which historically has not been a huge part of environmental studies, and which was a great thing that was happening at Yale at the time. But what was not happening also was looking at Native American land. So one of the reasons for the big emphasis on urban areas in environmental studies was environmental justice and social justice. But there was still this whole set of communities where there were incredible inequities that wasn't being looked at, wasn't getting any assistance, just had a lot of issues. And again, because of that interest in people's relationships with their environments, I've always had a really strong interest in Native American relationships with their environments, trying to avoid a romanticized view of that. There is very much a relationship and a sense of responsibility to the natural world, but there are also a lot of social and political nuances associated with how that plays out in reality that really fascinate me. I'm not Native, but this is what I've been doing for over 20 years. If you're interested in it, I also teach part-time at UNM in the Community and Regional Planning Program, which is the home of the Indigenous Design and Planning Institute. That's one thing to look at. Because I teach, I have a tremendous number of articles and resources that might also be of interest. And if you want a reading list or a syllabus, feel free to email me and I can send you more information that can get you thinking about it.
Okay, thank you. I think we have time for one more question. Do you see any major positive legal developments, including BIA, Bureau of Indian Affairs, maybe? Policy for Native Americans on the horizon?
There are incremental changes that are positive that do happen between agencies and tribes. I didn't even bring up Standing Rock, although that kind of surprises me now that I think about it, because obviously it was in the news and it was huge. But out of Standing Rock, for example, the Army Corps of Engineers began having some more conversations with tribes about possible improvements to consultation and to their process. So things like that happen. There are definitely positive examples at the regional level and the local level, particularly some of the ones in Washington State. And those are just terrific examples of good regional planning and how people come together in the checkerboard area especially and try to manage differences of opinion about land use and also resolve environmental issues. So there are positive things happening all the time, even in the face of larger political issues.
Great. Well, good. I like ending things on a positive note, so I'm stopping there.
Great.
So Sharon, thank you for joining us today, and for the New Mexico chapter for hosting today's session. I was telling Sharon before that I was very curious to listen in on this webcast, particularly since we don't have a lot of tribes in Northeast Ohio that we need to plan for. So just to kind of get a different perspective is really neat. And based on our poll, it appears that the majority of the folks on the call aren't currently planning for tribal communities, so they must have had the same idea I did. So again, thank you, and thanks to everyone for joining us, and have a great weekend, and we'll talk next time.
Thanks, Christine.
Thank you.